to those small business operators in compliance with the federally required regulations. The department has acted as the primary enforcement authority for the storage tank program in Wyoming. However, we've never been formally provided primacy of the program from EPA. There's been some disagreements between the two. Nonetheless, the EQ has been acknowledged as the formal enforcement mechanism for the underground tank program in the state. So since 1990, we've operated as that, and we've been the face of the program and kept some separation between the federal government and the state and the operators by being that middleman and being the intermediary and operating the program. In 2005, there were some changes at the federal level. The federal EPA finally got around to issuing the regulations to incorporate those 2005 changes in 2015. After 2015, we started the process of updating our regulations to meet the minimum requirements of those federal regulations so we can pursue official primacy of the storage tank program in Wyoming. And with that background, I think I'll turn it over to Adrian.
Yes, good morning. I'm Adrian Ducharme. I'm the interim storage tank program manager. I really just wanted to start off with a brief kind of agenda, if you will, for the next half hour, 45 minutes. Has been presenting to the owners and operators for the last couple of years about these 2015 federal rule changes that we're currently implementing. After that, we did receive some comments from the Environmental Protection Agency on our rules packet. At that point, I'll jump in and kind of walk you through those comments. That will open comments from the group here at large. But I thought this morning I would just start with, of all things, a picture of a tank. Imagine that. Here, probably later that afternoon or the next day, those were backfilled, and so they, it's very rare situated as they are in the tank basin. But I guess what I really wanted to point out with this next slide is that you're going to hear a lot about under dispenser containment, and that's what these are. The tank basin is in the background, just across the street from the chapel there. You're looking at the under dispenser containment sumps that have been installed at this location, and this is again from the same orientation. The view of the gas station that you'll typically see as you drive up and fill your vehicle. Again, the dispensers and above those under dispenser containment sumps. And in 2015, the federal government is passed the revisions to 280 and 281 of the CFR, where for the first time we're going to start integrity testing the under dispenser containment sumps. The transition sumps, which is in the foreground there where that large manhole cover has been removed. Lastly, this is the same location, just looking west instead of east. You're now on top of those underground storage tanks. The manhole cover has been removed in the mid-ground. And all of those sumps are now going to require periodic integrity testing, which is one of the newer aspects of what the regulations in 2015 require. I don't recognize it at this point. This is the new Big D up in Laramie. The old High Country Sportsman is there on the right of the screen. They actually kept that station operational until the new station was complete, and then they tore down the old one. So again, I just wanted to start with a few images. Oma's going to have some additional pictures for you to kind of identify some of these fuel system components that, again, once they're installed, don't readily make themselves obvious At that point, I was going to turn it over to Oma and let him touch on the regulatory history and then also get into the meat of what the rule changes at the federal level mean for our rules and regulations that we're presenting today.
Thank you. Once again, my name is Oma Gilbreth. I'm the compliance supervisor. I'm in charge of the inspectors that inspect all these gas stations to make sure that they're in compliance with rules and regulations, primarily to make sure that they aren't leaking, or if they're leaking, that we detect the leaks in a timely fashion. We also try to make sure that they're using leak prevention measures as well. My presentation addresses changes and updates to the current rules and regulations regarding underground and above ground tanks. When we talk about USTs or underground storage tanks, we use the acronym USTs. If we say above ground storage tanks, it's ASTs. We regulate petroleum and hazardous materials and commercial underground storage tanks having a capacity of 110 gallons or greater, and farm and residential tanks of 1,100 gallons or greater. Heating oil USTs are exempted. We also regulate above ground storage tanks or ASTs that are used to sell fuel retail to the public. We've applied for primacy or state program approval multiple times. And in the past, the applications were declined for a number of reasons. Prior to 2005, one of the issues is we weren't inspecting the facilities quick enough and we weren't cleaning the sites up quick enough. However, we think now with our new, if we get these rules incorporated, very good primacy. Since 2009, Wyoming, we have to report to the EPA what's called significant operational compliance for our facilities. Since 2009, we have never been below 5th amongst all the 50 states. And if we reported the highest compliance rates among states in 2013, 2016, and in 2017. We just reported a half-year or semi-annual report, and we were actually second behind Delaware. So we actually report with the work with the marketers and our program, we consistently have the highest compliance rates in the country. So we would really like to get primacy. So in 1988, that's when the first federal UST regulations came out, and the EPA enacted 40 CFR 280 and 281. In 1990, the Wyoming legislature enacted Wyoming Statute 3511, Article 14. This created the corrective action account and financial assurance accounts and authorizes the DEQ to promulgate regulations for storage tanks. These are two quotes directly from the statute. These are very important. The legislature realized that the owners and operators couldn't operate in these small communities because they would have to pay to clean these sites up. Also, one of our goals is to obtain primacy. And they also recognize the pay for these cleanups. So we're just trying to, they created our program to help these people out in these small communities. In 1994, Chapter 17, Water Quality Rules and Regulations was enacted. Basically, we mimicked 40 CFR 280. 1995, the Wyoming legislature created a tail above ground storage tanks actually into the program. So we actually as well that are used for retail purposes. 2005, the feds enacted the Energy Policy Act of 2005, and the EPAC did not change 40 CFR 280. However, it required states to promulgate regulations requiring operator training and licensing, double wall installation requirements, and red tag requirements. I don't know if you folks remember, but back in 2005, we actually went through a rulemaking on Chapter 17. And then in 2007, we also made some changes as well, 2008, excuse me. And then 2007, they created the Storage Tank Act of 2007. That was the Wyoming State Legislature enacted that. And the highlight in that is double-walled UST and double-walled underground storage tank pipe that were installed had to be double-walled and interstitially monitored. Then in 2008, we actually incorporated operator licensing requirements in response to the EPACT, and we also incorporated red tag requirements or delivery prohibition requirements. So if they're out of compliance meeting certain requirements, if they were, say, they failed to perform testing within 60 days, we were allowed to issue a fuel delivery prohibition order or notice of violation and order. 2012, we actually made some changes there as well. We went before the council and we actually had some changes then as well. We changed the licensing requirement for operators from 3 years to 5 years. We also incorporated retraining requirements, which basically said if we found one of those red tag violations, we could require the licensed storage tank operator to retake the exam within 90 days. We also changed the requirement for the storage tank operators to actually get a license within 90 days versus 6 months. 2015 was the first time that the feds actually changed 40 CFR 280, and that's why we're here today. So in response, we had to change the Storage Tank Act of 2007. There were certain exemptions for certain types of tanks, and those exemptions were removed with the 2015 revisions to 40 CFR 280. So we actually went to the legislature and actually had some changes taken out for the exemptions. So the 2017, we actually went before the legislature and made those revisions. They made those revisions. So because the STP does not have primacy, the EPA regulations are now in place in Wyoming. Technically, the EPA could come into Wyoming and enforce these regulations. However, they won't do it, or they haven't been doing it in the past. Since the EPA regulations were adopted in 2015, our program has worked hard to inform the regulated public of the new regulations through outreach and written correspondence. We've had over 880 compliance inspections completed since 2016, and each inspection report includes a paragraph reminding owners and operators of the upcoming EPA deadlines. Also, the tank invoices include reminders, and multiple reminder letters have been sent. So we've tried really hard to make sure that people understand that these deadlines are coming down the line. We've also done operator outreach. Each year, our program provides outreach to owners and operators, and we cover the regulations and statutes. In 2016, we started including a 1-hour presentation covering the new EPA regulations and how they will affect them. We also informed them that these regulations would be adopted by the storage tank program eventually. In the past 3 years, we have traveled across the state and have had over 250 operators and/or owners attend these meetings. So we've actually worked hard to make sure that these people know that these regulations are coming. We've also done storage tank tester and installer outreach. The testers and the installers are important because they are the ones that have to make the changes on the equipment in response to these regulations. We've had over 70 attendees at 12 of these meetings. We've also composed multiple guidance documents to assist testers and installers in interpreting the current and upcoming regulations. We have gone over these documents with testers and installers to let them know what's expected. So we've actually worked really hard to make sure that people know that this is actually coming down. Prior to the Wyoming Advisory Board meeting, Water and Waste Advisory Board meeting, we also held 5 meetings with the owners and operators across the state to let them know that these regulations are coming out. We also worked to make sure that if they had any comments, we were able to address them. We had 5 of these during August of 2017. We worked with the marketers on this, and so we actually worked with owners and operators in this as well with the marketers. So now, after all that, what I'd like to do is kind of give you a quick overview of underground storage tank systems, but also explain some of the nuances with these new regulations. So this is like Adrian showed, this is what an underground storage tank looks like prior to being filled up or backfilled. Most people, when they drive up to a gas station, all they do is they go over to the dispenser, pump fuel into their car, and don't even think about the tanks, all the equipment that's underground. So that's what a tank looks like. So this is kind of a diagram of an underground storage tank system. So you have your tank here. One of the things that we're going to be really talking about during the rulemaking here are the sumps. This is what's called a sump here. Then you also have your spill buckets where they actually fill the tank. And basically a spill bucket, that's a spill bucket. Here's another picture of a spill bucket. Here's the tank. Then you have your drop tube. This is where they fill the tank. And then over here, a lot of people call their dispensers. Everybody calls them pumps. Back in the old days, the pump was actually in the dispenser and they sucked fuel from the tanks. But nowadays, a majority of your systems actually are pressurized. And so you actually have a pump in the tank where it pumps fuel over to the dispensers. Problem is that with all this piping over here, if you're pumping over here, you have a tendency to potentially leak. And so you're pumping fuel into the ground, potentially. So that's where we start talking about interstitial monitoring. And when we're talking about interstitial monitoring, this is the tank down here. So you're pumping the fuel up into what they call the turbine head, and it goes over to the dispensers. Well, if you have double wall pipe, which is double wall pipe, and you have the primary piping fails, you have a secondary containment around that pipe, right? So that secondary containment conveys that product back to the sump right here. Oops, sorry. So this is your sump here. And so then it starts building up and you start getting product building up in the bottom of the sump. Well, then you have what's called a sump sensor. And you probably saw that reviewing the regulations. What happens is that product raises up and it causes that float to lift, and then it alarms at a console. So the owner knows that the primary product line has failed. One of the requirements that we were wanting to incorporate is requiring the sump to be integrity tested. If the integrity of this sump fails, all that product runs out into the ground and that sensor does not raise. So that's why we're actually, that requirement is incorporated to integrity test these sumps to make sure that those sensors will actually raise. The integrity testing on the proposed regulations will be every 3 years. They'll have to use what they call hydrostatic testing. They'll fill the sump up to a certain level, and then it has to stay steady for an hour, and it cannot decrease in level an eighth of an inch or greater. So this is what an actual turbine sump looks like. And if you look, you can see the sump sensor right there. It looks like a tube and it's got a float built into it. And you can see the wires and it goes over to a console and alarms. When we talked about the under dispenser containment sumps, there's sumps underneath of the dispenser itself. So if you have a leak inside of the dispenser, it catches the product and then it'll alarm the sensor underneath that dispenser, just like it would on the sump. These are important because a high percentage of our leaks that we detect or product that we detect at a facility comes from underneath the dispensers because people change out the filters and stuff, product drops out, goes down onto the ground. Well, with an under dispenser containment, it catches that product and prevents it from getting released into the environment. Okay, another requirement in the proposed regulations is the requirement to function test overfill prevention devices and to integrity test spill buckets or spill prevention devices. When a delivery driver comes up with his tanker, he connects a hose to the tank. He connects it right here. Actually connects it with a cam lock fitting, right? So when he's done filling the tank, when he breaks that hose loose, he pulls the hose away, product gets dropped out. Well, this spill bucket right here actually catches the product, and then they can drain it back down into the tank. There's actually a drain plug right here, and it actually drains it back down into the tank. So basically you're preventing that product from getting out into the soil surrounding the fill tube. It's very important. We've been finding, since this testing requirement by the feds has been required, we've been asking the people to submit the records of their spill bucket testing, and they're finding that in Colorado they actually did a study and they found that up to 50% of these spill buckets are failing. So it's very important to make sure that these things are tight, because us as taxpayers are having to pay for that cleanup of those releases from those spill buckets. So we need to make sure that those get tested. So they're going to be required to test those every 3 years with either vacuum or a hydrostatic test. Then we talk about overfill prevention devices. When they're filling the tank, they have to either have an alarm or they have to have an overfill prevention device, which is used like this one here. Once the level of the tank gets full, it has a float on the back, and what it does is when it rises, it throws back a flapper into the flow of fuel into the tank, and it stops the flow of product. We call that a butterfly or flapper valve. Also, on the new proposed regs, they talk about a ball float overfill device. Those are going to be, they cannot install new ones. They cannot repair them, because they're very inefficient overfill prevention devices. But they will have to test them every 3 years, and if they don't work, then they're going to have to either put this flapper type or an alarm. An alarm, they have to alarm at 80% or 90% capacity. The flapper valve has to restrict the flow at 90% or 95% capacity. So there you go. That's just kind of an idea of the equipment and how it works. And as we go through, we'll discuss the new changes affecting this equipment. So the new federal rule changes, we're going to give a quick summary here. The new regulations require walkthrough inspections, spill prevention equipment testing, like we talked about, overfill prevention equipment testing, integrity testing of piping, secondary containment equipment used for interstitial monitoring, such as containment sumps. They also added a requirement for operator training, which was already included in our rule, which we had incorporated in response to the 2005 Energy Policy Act. We added requirements for secondary containment, for new and replaced tanks and piping, and they also required compatibility for emerging fuels. When we talk about emerging fuels, we're talking about fuels that contain ethanol or biodiesel, and we're talking about ethanol concentrations of greater than 10% ethanol or greater than 20% biodiesel. They also updated, this is made editorial and technical. Our quick summary of the proposed changes. We incorporated the federal rules in 2017. We moved rules and regulations, chapter 19, which is the financial responsibility regulations, into this chapter. And we also changed to chapter 1, solid and hazardous regulations. We also reformatted the regulations to meet the rule, and we updated all standards publications, moved references to the, which is the name and date. So now what I'm going to do is a quick run through. So section 1 through 5 updated codes and standards. We updated the recommended practices. We also included USTs that are no longer airport hydrant tanks, oil water separate constructed USTs. Definitions were updated to include certain EPA definitions, such as the different types of tank operators. Section 6, when I mentioned ball float valves, the actual correct term is flow restrictors and vent lines. They will no longer be allowed to be installed as a primary overfill device, nor can they be repaired. Whenever new replacement dispenser systems are installed, the dispenser and the shear fire valve or flex connectors are replaced. Under dispenser containment has to be installed. I showed you that under dispenser containment. So anytime they do those major modifications, they have to install it. All newer replacement USTs and piping must be double walled and interstitially monitored. That's actually been required since 05, but we actually incorporated it into section 6, which we didn't have before. Section 7, substandard USTs. Substandard USTs cannot be brought back into service if they've been in TOU for longer than a year. Permanently closed USTs cannot be brought back into service unless they meet certain requirements. Section 8, repairs allowed. Repaired secondary containment systems are being integrity tested within 30 days of any repairs. One thing we also incorporated is whenever the primary or secondary wall of a double wall tank fails, it is to be repaired immediately or permanently closed. Reason why we put that in there, back in the rules that are currently in place, we've had people where the primary portion of the tank fails and they try to tell us, oh, well, now it's a single wall tank. We want to continue using it as a single wall tank. Well, that secondary containment on that tank is not intended to routinely contain product. It's only intended as a temporary fail-safe to prevent a release of product. Well, there was nothing in the rules to prevent this, so what we wanted to make sure that it was outlined in rules and regulations. Section 10, spill and overfill control. Spill prevention equipment. When I talk about spill prevention equipment, we're talking about what the industry calls spill buckets, are to be integrity tested by a licensed tester unless the spill buckets are double walled and interstitially monitored on a monthly basis, and all are to be tested installation and every 3 years thereafter. Overfill prevention equipment is to be function tested by a licensed tester every 3 years. And testing of sumps, transition sumps, and under dispenser containment sumps used for interstitial monitoring of piping are to be tested by a licensed tester every 3 years thereafter, after installation and every 3 years thereafter. Corrosion protection. Repairs are to be made by a CP expert within 30 days of failure. The reason why we put that in there is to make sure that the repairs were designed in a timely fashion. A lot of times we're having problems recently where the CP expert just sits on it and doesn't design the repairs until like 10 days before the facility's eligible for a red tag. So we wanted to make sure that they actually had a sufficient time frame from when it was designed to actually get it repaired. We also included an allowance for stake anodes to be connected to flex connectors. And they can be installed by a CP tester without having to have a CP expert do the work. The way it's currently worded in the regulation, it has to be designed by a CP expert, and this is pretty minimal. Section 12, compatibility. Compatibility check is to be done with biofuel blends containing concentrations of greater than 10% ethanol or concentrations of greater than 20% biodiesel. We are seeing a lot of issues recently with these biofuels, a lot of corrosion to equipment and stuff like that. So we want to make sure that the equipment is compatible with the product and we don't have this corrosion. We also included a requirement that they are required to notify us at least 30 days prior to a change of service when they're trying to change to a higher concentration biofuel blend. Section 13, inspection right of entry. Already owners are required to provide access to equipment, but we also put a disclaimer in there is if the owner is unable to open access points, requiring DEQ personnel to open access points, the owner is responsible for any damage to equipment or property. I've actually had some instances back in the past when I was doing the inspections where you go over to open up a manhole and you break the handle on the manhole cover. Well, we just wanted to say, hey, if you're making us do this, even though you're required to do it, you're going to be responsible for the repairs and damages. Record keeping, we updated a few things in there to require them to keep records of testing, records of compatibility, records of monthly inspections, and to keep documentation of Class C operator training. We also updated the requirement for monthly inspections. Right now, the way it is the facilities, if a Class A operators over more than 2 facilities, they have to do a monthly inspection. Well, the new EPA regulations actually requires them to do a monthly inspection no matter what, unless they actually receive intervals, fuel delivery intervals exceeding 30 days, and then it's before every delivery. So we actually incorporated that into this section. We also allowed, in the past, we required the monthly inspection to be done by the Class A or B operator for the facility. We're actually going to allow licensed testers to do this monthly inspection. So the Class A, B, or operator or the licensed tester can do these monthly inspections. Section 14, all reference to sump sensors being used as automatic line leak detectors have been removed. And this is due to a dispute with EPA over whether sump sensors can be used as automatic line leak detectors. And we've decided to determine if sensors can be used on a case-by-case basis utilizing STP guidance document number 29. This is actually one of the comments that EPA made on our regulations. And Adrian will address this here at a later time, but we actually had a reference to sump sensors as automatic line leak detectors, and we had to take it out. Section 16, petroleums with a UST or capacity of greater than 2,000 gallons. One of the EPA requirements was that a site assessment must be conducted prior to performing groundwater or vapor monitoring. This basically allows the owner or requires the owner and operator to determine if the site's contaminated before they actually use groundwater or vapor monitoring, because if they do, it's going to fail anyways. Section 18, one of the minor changes was that if an owner operator performs tank tightness testing, they have to keep the results until the next test is completed. Section 19, if they have a release at a facility, they're required to report it to the fire department, having local jurisdiction. We didn't have that in the regulations, so people were actually reporting a spill to us, and then the fire department would call us and say, well, why didn't they report it to us? So we just want to make sure that the people do this because it's required by the fire code. We also put in a requirement where if they have liquid in their interstitial spaces on their tanks or piping, they have to report it to us. We already covered this as far as if the primary wall of a secondary contained piping system fails, test the secondary containment must be conducted to determine if product actually has been released. Section 2224, we updated the reporting numbers and website address. We also, all spills of certain sizes are required to be reported to the National Response Center. We did not have this in regulations, so we actually incorporated it so the owner operators know that they're required to do this reporting. Minimum site assessments. If temporarily out of use longer than a year, and the site is not contaminated, an MSA will be required unless a written extension is issued. We actually had a change in the statute where it said if they're temporarily out of use for longer than a year, they would have to be removed, or we would have to issue an extension, and they would. So that's why we incorporated it. It used to be that they would have to do an MSA if they were temporarily out of use for 3 years. Now we bumped it back to 1 due to the statutory change. Temporary closure is a quick summary of that. One thing that we did put in there, if a tank is temporarily out of use, they still have to have a licensed Class A or B operator over the tanks. One other thing that's going to cause some heartache with the owners and operators, the EPA regulations only allows a tank to be temporarily out, or allows a tank to be temporarily out of use for 3 months before they have to drain and cap the piping. We had it in as 6 months. So this is actually going to impact some of our park service, some of our seasonal places like up in Yellowstone and things like that. So they're actually going to have to drain and cap their piping now after 3 months. On the AST requirements, the CP testing, the way it's set up right now, it's once every year. We're changing it to 3 years, so it's kind of like the same as the USTs. All new and replacement piping shall be double walled and interstitially monitored. We actually incorporated that because to make it similar to what the UST regulations are. We changed the ladder requirement right now. The way it is, even if an above ground storage tank is only 2 foot high, they're required to have a ladder to get to the top of the tank. So we thought we would actually go with 6 feet versus all tanks having to have a ladder. Another thing was all ASTs have to be compatible with the product stored. We did not have that in there. Section 36, AST leak detection. Inventory control will not be required if all of the tank and piping are isolated from ground contact and can be visually monitored, or if the AST is isolated from ground contact and the underground piping is double walled and interstitially monitored. Sorry. Okay. Okay, and the underground piping is double walled and interstitially monitored. Sorry. The reason why we changed that is if you can actually see the whole tank system, you shouldn't have to do inventory control. I mean, it's obvious if the tank is leaking. The way the regulations are set up right now, it says all ASTs have to do inventory control. So we just tried to make it a little more logical here. Section 44, delivery prohibition. Now this is also known as a red tag order. Now when we do this, when we issue a delivery prohibition, it's not like I myself can just write a delivery prohibition. We actually do a notice of violation in the order. So we actually have our checks and balances and all that. It actually has to be signed by the director and the administrator and all that. So what we did is we had to make some changes to these red tag violations. One thing was line leak detector function testing and line tightness testing. We changed it from 60 days to 90 days because right now the way it's written, if they have to do an operator's annual inspection and it's past due by 90 days, then we can red tag them. But if they're required to do line leak detector and line tightness testing during the operator's annual inspection. So if they're both required at the same time as the operator's annual inspection, we need to make the deadline the same. So that's why we did it. Feed deadline was changed from September 1st to April 1st. If a tank has been installed or substantially modified without written authorization from the DEQ, we've actually had this several times where people actually have gone in and started operating the system without our written authorization, which is required by statute. We want to stop that. So we incorporated that into the reg tag requirements. Installer licensing. On section 45, we updated it from 3 years to 5 years to make it similar to what the operators have. Storage tank operator licensing in section 46. The owner operators are required to maintain a list of all their licensed operators and their trained personnel. They're also required to keep records of retraining. So if they have to retrain due to notice of violation or whatnot, then they need to keep records of that retraining as well. Cathodic protection tester and corrosion expert licensing. The way the regulations set right now, the Steel Tank Institute license is good for 2 years instead of 3 years. Well, their certification is for 3 years, so we just wanted to make sure that they're the same as NACE certification. Then tank and line tester licensing. The current regulation only allows them to be licensed for 2 years. We updated it to 5 years, so we're kind of across the board as far as licensing is concerned. So section 50, we have the previously deferred tank systems. These are mainly like your airport hydrant systems. I don't know if you folks know what an airport hydrant system is. It's basically, they'll have a big tank farm and they'll run underground pipe over to the jetways. And then they have a fitting on the ground and they just hook the hose up to it and fuel up the airplanes. Well, we don't have any of those in Wyoming. We probably won't, but we had to incorporate in these regulations. So those were previously exempted. Now they're actually required to, they actually have requirements. Also previously deferred was the field constructed underground storage tanks, like big fuel tanks that were actually constructed in the field. Those were previously deferred. They're actually regulated as well. So this is a quick summary of the updates that were done. I probably won't go into it because we really don't have any of these tanks in state that we know of. So anyways, these were incorporated at the end of chapter 1. These are the new EPA regulations. Also, part N of chapter 17 or chapter 1, the new chapter 1, proposed chapter 1, is going to incorporate all the requirements for financial responsibility that were covered in chapter Wyoming Water Quality Rules and Regulations, chapter 19. We've actually just moved all of that over into chapter 1. So we'll be eliminating Water Quality Rules and Regulations, chapter 17 and chapter 19 and incorporating them into chapter 1. And that's all I have as far as the updates to the new chapter 1.
Thank you, Oma. At this point, I'm going to address the comments that we did receive from the Environmental Protection Agency during our public comment period. The 3 notes that you see here are the formatting required when language that was proposed is now being struck down. The point I want to make is that the clean version of our chapter 1 has all of these changes incorporated in them where they were appropriate to do so. The other point I wanted to make is that when EPA made their comments, they identified the first 3 comments as major state program approval issues. And so I'll spend more time on the first 3 issues, each of which we did address. The remaining comments, comments 4 through 36, were recommendations by the Environmental Protection Agency. We did incorporate some of those recommendations. Many of those recommendations did not require any changes to the proposed rule. As such, I'm just going to briefly present those comments that, again, our response was that we weren't going to change our chapter 1 rules and regulations. So again, the first 3 comments were the major ones. Comment number 1 had to do with the compatibility of biofuel blends. Again, those include biodiesel greater than 20% and ethanol fuels greater than 10%. Their concern was that we shouldn't be requiring all fuel system components to be compatible, that was too strict a standard. As such, we agreed with that observation, that comment. And based on that, we made some changes to the proposed rules that we're hoping to adopt today. And those are kind of outlined in the rest of this slide. Moving to the second major comment made by EPA. Oma discussed this in his portion of the presentation earlier. The use of sump sensors as automatic line leak detectors has been modified to match the federal requirements. And again, we have a guidance document number 29 that additionally spells out how these sump sensors can be used to satisfy the interstitial monitoring requirements that are statutory here in Wyoming. There's actually 2 pages associated with that. A lot of it was just removing language and then reorganizing the section so that everything followed alphabetically. The third comment was the last of the major comments made by the EPA. They did identify that our statute has a clause in a definition that excludes oil water separators. The EPA identified that that is not consistent with the federal 280, 281. So our response to that is we agree, and we are going to have to strike through a portion of the definition that's in our statute. So that's something that we'll be tackling during the next legislative session. Again, it should be fairly straightforward. It's just going to be a strikeout of a clause that's in a particular definition for under the exclusion section. So again, that touches on the 3 major comments that EPA received. They had a number of other comments that they entitled as recommendations. The 4th comment we did agree with, and so we incorporated some changes to our rules and regulations that have to address with cathodic protection. Essentially, Wyoming requires all steel tanks to have cathodic protection. And so that necessitated some changes to the rules that we have in front of us today. Comment 5, EPA identified that, we haven't specified dates for the implementation of these latest changes. We've responded that since we don't have primacy, the federal dates are in effect. And so that's why we didn't come up with dates of our own. Comment number 6, again, they had a question about annual inspections. We don't have primacy for the program, and so we didn't change our Chapter 1 rules based on comment number 6. Comment number 7, having to do with Class C operator training. We do agree with that comment, and based on that, had some minor changes to the rules and regulations as shown in that response. Comment number 8, they're asking that they do not specify how long our records are kept. We had to go ahead and identify that those are addressed in Section 13I, and therefore no changes are required. Comment 9, where the records to be maintained. We point them to the Section 13I where that is specified. Comment 10, they're asking about section 18. Yes, we're confirming for them that that is the appropriate reference and no change was necessary. Comment 11, again, a question about the appropriate reference of the section. We clarify where to find the information on system compatibility. No change is proposed based on the comment. Comment 15 is rather wordy. It has to do with the implementation of our corrective action program. Our response towards the end was that we're not going to change the rules and regulations based on the comment. We do provide some additional language to the EPA to clarify where information is in our regulations pertaining to the site checks that are required during suspected releases. Comment 16, again, a general question about the state's corrective action account. Jumping to the end of our response, no changes proposed in the regulations. However, again, we did provide some additional language to clarify the implementation of the state's corrective action account. Let's see, is that comment 18? Yeah, there we go. Okay. So,
Yeah, 15.
Oh, I'm on 15?
Yeah, go up.
Thank you.
One more.
Thank you. Comment 18 talks about the eligibility of a release. Their policy question for the state, jumping down to the bottom, what is the state timing requirements for sites under the state corrective action account program with free product? The response did not require any change to chapter 1. We just provide some additional clarification that we have a guidance document number 11 that directs the state's response when we are notified of the presence of free product at a regulated facility. Comment number 19 talks about prioritizing the site in the instance of a release. Jumping to our response, again, no change was necessary for chapter 1. We provide some additional language that spells out, again, the implementation of our corrective action program. On to comment 20. They're asking about section 25, does not reference standards found in part J. Again, no change proposed based on the comment. We just provide some additional clarifying language identifying that we do have cleanup standards listed in part J. Comment 21, again, a question about the implementation of cleanups at sites where under the purview of the corrective action account. Jumping to the end of our response again, no change in storage tank program chapter 1 was necessary. We do provide some additional language identifying the previous problem that the state of Wyoming had, in that we had a large number of contaminated sites to address all at once. We developed a system where we address those through a hazard ranking system. And again, no change was necessary based on that response. Comment 22, another question from the EPA pertaining to our cleanup program's eligibility. Jumping to our answer, we will develop a guidance document that lists all of the regulated substances that are covered in our statute. And so we had them in the original appendix of chapter 17, and we're going to move those out of chapter 1 and just provide them in a guidance document. Comment 23, again, a question about our corrective action plan for fund-led sites. Our response is that no change is necessary. We do provide additional language that shows the process that the state follows in the instance of a release where the state takes the lead. Comment 24 is a referencing question. Our response was that, well, no change is necessary based on this comment, and we provide additional language to identify the minimum site assessment is required in section 29. Moving to comment 25, the question talks about the financial responsibility account. Am I on the right slide?
You're back.
Oh, okay.
Go back.
Okay. Thank you. So again, on comment 25, they talk about the additional information on what the fund covers to determine if our financial responsibility meets CFR 281. No change was necessary based on that comment. We do provide additional language discussing the implementation of our financial responsibility account. Comment 26 talks about storage tank operator licensing. We do agree that we'll revise our exam to discuss the topic there in the comment, but no change was necessary to the rules and regulations in Chapter 1. Comment 27, specifically about previously deferred emergency generator tanks. We provide the clarifying response that we've always required them to have leak detection and no changes are necessary in Chapter 1 because of the comment. Comment 28 is a comment about federal definitions that are used. Oh, it's not. Thank you. Comment 28 talks about federal definitions. Our response is that Section 5 states the definitions in the rule supplement and that no change is necessary based on the comment. Comment 29, if possible, please add the language found in a 280-34BL or 1. The department does not allow steel tanks to be installed without cathodic protection. Therefore, the section is not applicable. No change proposed to the regulations, consistent with our comment response to comment number 4. Comment 30, the next slide, pertaining to Section 61 release requirements. We do agree with the comment and have added the language shown there in that slide in Section 61. Comment 31, applying to Section 62, a question about what happens in the instance of bankruptcy. Our response, no changes necessary in Chapter 1 based on the comment. We do provide some additional language talking about how the corrective action account deals in instances where we've had a owner-operator enter bankruptcy. Comment 32, Wyoming does not require facilities that are ineligible for the corrective action account to immediately investigate and confirm releases on site. We point out that we actually do that in Section 21, therefore no changes are necessary. Comment 33 talks about requiring notification for the evidence of financial responsibility. Jumping to our response, no changes necessary to our rules and regulations. We do provide additional clarification language about how we implement fees and how we recover fees when necessary. Moving to comment 34, discussing Class A and Class B operators. This is the retraining within 90 days of employment with a UST company. The federal requirement is limited to within 30 days of assuming duties. We've agreed with that and have changed our provision from 90 days to 30 days to match the federal rule. Comment 35, talking about Class A and B operators that need to be retrained within 30 days of the determination of noncompliance. Our response is that we agree with that comment and have modified our section 46 and 44 accordingly to again be consistent with the federal requirements. The last comment, comment 36. If you want to dance to it, Emma. Wyoming does not have analogs to 40 CFR 280, 245B 1 through 3. And we had clarified for them that record-keeping documentation is in section 46H. Therefore, no change is proposed to our chapter 1. So with that, we've covered the comments made by the Environmental Protection Agency and our response to them. They were the only comments we've received during the comment period. We do understand that individuals can make comments at this time as well, but it does conclude our presentation. And at this point, we can turn it back to the EQC board.
Well, and before we do, as you heard, the changes we're proposing are quite significant. They're significant, but they're the first changes we've made of such a nature to our program, and near, I think it's beginning of the program. And you know, we just want to say thank you to the Wyoming Petroleum Marketers for working closely with us on the development of these rules. We feel that it was a very collaborative process where we certainly listened to their concerns. They heard our concerns, and I think we came up with a good rule package. So with that, I'd like to basically conclude our presentation and once again request the council repeal chapters 17 and 19 of the water quality rules and regulations and approve chapter 1 of the storage tank program rules and regulations.
Thank you. I'll open it up for questions at this time. Deb?
No, thank you.
Bye.
Yeah, Mr. Hearing Officer, just very early on in your presentation, you mentioned the primacy with EPA. Can you just say what that is and what it's been? That never a refresher for me.
Yeah, sure, Councilman Cora. EPA's primary issues with our program in the past have been the way we prioritize and conduct remediations at contaminated sites. Other states and the feds, whenever they find a contaminated site, they want people to rush out and begin remediation immediately. Our program basically prioritizes the site and places it in a project, or it has historically. We've had 625 contaminated sites in the state. I think 1,200 and some have been cleaned up and closed. We've got, and Almost certainly has the number, and Adrian has the numbers. We've got, and the remaining sites, the known contaminated sites, are all entered into project. They're in some form of, except for apparently, or in some form of either investigation or active remediation or monitoring for compliance. I know 2 of those sites we're not going to get to for some while because one site is a basin, a tank basin located underneath the Dave Johnson power plant. And the other contaminated site is a station right across the street from the former Grable refinery. And so we really don't want to expend money trying to clean up that site until we make progress on some remediation at that site under some different programs. And so we've done a really good job of addressing the contaminated sites as we find them. Now that our backlog's been addressed, that issue with EPA is no longer much of a concern based on our conversations. There has been discussions with EPA about Indian country, what we view as Indian country and what they view as Indian country. Our conversations with EPA have indicated that we should be able to find a way around that by including some language in our primacy agreements that acknowledge that obviously EPA has primacy in Indian country, but we have a disagreement on what that might be. But I think that shouldn't stand as an issue for primacy for us. We had a call with EPA, was it just last week, and they sounded very positive about the state pursuing primacy once these regulations are addressed, as well as our statute change that we need to do.
Good. One more question. The oil and water separator regs, you moved those as a result of an EPA comment, I guess. Now, is there any overlap or double regulation of the regulated community? Yeah.
Councilmember Cora, there is an exemption if you look in, I think it's section 2. There's a section that says that they are oil water separators that are specifically exempted are the ones that are regulated by WIPDs. I think it's WIPDs, and there's several other programs that are specifically exempted of oil water separators. There's certain types that are specifically exempted. And I think it's in section 2 of.
And so you're picking up the exempt, and the EPA wants you to pick up those that are exempted?
Right.
So
Yes.
the operator, the oil and gas operator is not going to be seeing any regulatory duplication.
Correct.
Yeah.
Yeah.
Correct.
That's all.
So, Mr. Esch was discussing the main issue that the EPA has had with this program is the fact that we prioritize rather than just going in and fixing problems. And then they had a comment on it in their comments to this regulation, in which we said, well, we like our program, we're not going to change it. Is that going to be an issue in losing primacy after doing all of this? Or not getting primacy, not losing it, but not getting it?
Councilman Lally, once the program receives primacy, it's very difficult for EPA to get it back. So I don't foresee that being a problem. They'd be well aware of the way we operate our program going into that, and once they issue primacy based on that understanding, I feel it would be very challenging for them to get the program back. And furthermore, they're not operating the program already. They've had Wyoming operate our program since its inception. So I think that they've acknowledged that what we've done has worked in the past and addressed our backlog. So yeah, I don't believe that would be an issue.
Okay, that because we still haven't addressed the main reason why they haven't given us primacy, they're not going to not give us primacy?
I guess my response to that would be that it's really kind of a remnant of the historical application of our program, in that we had a large backlog a number of years ago that the state used a contracting process to address, and we are not caught up with that backload of contaminated sites. Are we still identifying facilities that have had a release? Yes. And we actually have a contracting mechanism that is available to us where we can start corrective action within a matter of weeks and months. So the issue is really more a kind of a historical concern that EPA had with the implementation of our program. And we can make the case that, with our backlog now addressed, our contracting mechanism is flexible enough where we can take corrective action in an immediate time frame.
Okay. And then my other question is, are they going to then maintain primacy over Riverton, or is this, this is what I assume started the whole hubbub over Riverton a couple of years ago, and who's going to have primacy in that area?
Councilwoman Lally, and I might look toward our AG on this one to provide the most up-to-date information, but it was my understanding that the last ruling from, I think, the 10th Circuit found that the city of Riverton was within the state's authority. And James, do you want to comment?
My understanding, so the person who's going to decide that is the justices of the United States Supreme Court if they choose to do so. And so far they have not taken to do so. My understanding is that they have an extension to apply for an appeal to the Supreme Court. They have not done it yet.
So at this point, Riverton belongs to the state of Wyoming. Okay.
I just have one question. What does the integrity test consist of? Is it they bring in equipment and pressure it up and test it, or?
Councilman Flintner, which integrity test?
Well, like for the sump pumps, those 3-year timeline things, those
Right.
mechanical workings underground.
Okay, for the sumps themselves, it's a hydrostatic test. And what they do is they fill the sump to within 4 inches of the highest penetration in the sump, and they let it sit for an hour. And it cannot decrease greater than 1/8 of an inch. The level cannot decrease greater than an 1/8 of an inch. It's the same with spill buckets. However, spill buckets, they also have a vacuum test where they will actually put a cover over the top, or actually they'll put a plumber's plug in the drop tube, make sure that no air comes up from the tank, but they'll block off that drop tube or the fill tube. And then they'll put a cover over the top of the spill bucket itself. And they actually have a valve on there, and they'll put a vacuum on that spill bucket. And I think it's like 5 minutes that they cannot see a decrease in the vacuum, in the level of mercury during that 5 minutes.
So basically pretty simple, not really expensive, and pretty straightforward.
Correct. The main expense on the sumps and the spill buckets, if they're doing hydrostatic testing, is the disposal of the water after the testing. But we've agreed that they can use that water at multiple sites.
They'll probably just put it back in the gas tank.
No.
I think I've gassed up at some of those places. Okay, well, if that's it, is there anybody here that wishes to testify one way or the other, or somewhere in the middle? Or you just state your name, please, and whether or not you're going to testify for or against. Or
Thank you,
neither.
Chairman, members of the council. My name is Mark Larson. I'm the Executive Vice President for the Wyoming Petroleum Marketers Association. We're the licensed fuel distributors that are downstream from the refineries and the terminal racks. We represent about 75% of all the refined product that goes through Wyoming. Because most of my marketers also own convenience stores, we represent the majority of the 350 plus convenience stores in Wyoming. We are the regulated community that this is addressing. I'm testifying today not because we have concerns with the rulemaking moving forward, but to explain why we think the rule is very appropriate to move forward today. A little bit of history, back in 1990 when we had a lot of the issues that came out as a result of MTBE and some of the other things you saw in Love Canal, EPA responded and we have the storage tank program today. Over those years, the petroleum marketers have been upgrading their systems to meet the EPA requirements, and as a result of that synergistic effort, if you would, we have seen releases reduced in significance and releases reduced in size. So the program is working. WPMA members, the Wyoming Petroleum Marketers members, are proud of the compliance record that you heard Oma talk about earlier that we have mutually achieved with STP and the industry. Consistently being the highest compliance in the country. I'm sorry to hear we went to number 2. We'll fix that. The marketers recognize the importance of storage tank regulations that assure Wyoming's environment is not negatively impacted by our necessary operations. The EQSTP has done an exemplary job of engaging the regulated community in every step of the process. From reviewing the bill, upgrading the statutes, and providing a platform for this rulemaking, to the several meetings working with the rule details with the industry, to the significant outreach that they did statewide, in which I attended all of them. The EQSTP has worked hard to be effective and listen and apply the well-reasoned regulations. Did we get everything we want? No, we didn't, but that's the way that it works. What we did get was ample opportunity to be able to exchange ideas and have our suggestions listened to and have a common sense applications put on the ground and in the regulations. Given the fact that Wyoming is not a primacy state that you've discussed at length and Director Cora and I have talked about many times at the Capitol. The EQSTP still applied operational realities and genuinely listened to the industry, to the regulated community, while assuring the EPA guidelines were indeed followed. This is necessarily not an easy process. We understand that. However, from our perspective, the necessary due diligence has been performed and it has been performed admirably. We are aware and believe that you also may be aware that many members of Congress are currently being asked to sign on to the Moran letter from Kansas Senator Moran, requesting that the EPA delay the new testing requirements for several reasons that are not atypical to Wyoming operators. Should EPA relax the testing deadline, DEQ has assured us that they will also recognize those delays in the guideline payment. I tell you this for your information, but also just to be sure to go on record with that. Given all the hard work performed by the DEQ STP and the regulated industry, WPMA requests that you pass the proposed rule. We've been there every step. We appreciate that. I'll stand for questions.
Yep.
No. Thank you.
No. Anyone else? That's the end of it. I'll close the testimony. Entertain a motion.
I move that the rulemaking package as presented.
Do we need to?
Yeah, actually, I probably.
Just
yeah.
Move to approve reasons and the rule package as presented. 18.5101. 8.
So that's all deal, right?
The rule package. So you just want to approve the rule package.
Mr. Herring, with the clarification from Mr. Rubin, clarify the motion. That would be.
I'll second.
Okay.
I do. I just want to thank the DEQ for the outreach they've done on this. I mean, I was very happy to see you've been out talking to the regulated community, getting input, a number of opportunities. I think that's the right way to go about these things. These rules are complicated, and it's just important to get out in front of the public and the folks who are going to be affected by these. I really appreciate the effort you've done to do that as you brought these rules forward. Thanks.
Thanks. Deb? Aye or nay?
Aye.
Bagley?
Aye.
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 I vote aye as well. Okay, with that, we can move into the next one unless do a break. I was getting to you, Dave. I knew you'd be coffeeed up. I will take a 10-minute break. Does that work for everybody?
Sounds good.
Oh, good job.
Thank you. Yeah, thank you.
Yeah.
Well done.
Department of Environmental Quality. I'm the policy and planning analyst for the division, and I assist with the administrative tasks related to the rulemakings that we bring before you. We'd like to thank you for meeting with us today so that we can bring our docket to you. To my right is my programs manager from Water Quality Division. This is Jennifer Zigmund, and she's here on behalf of I've upgraded someone. She's here on behalf of Administrator Frederick, who is unable to attend today. The rulemaking that we're bringing before you today is actually fairly straightforward and simple. The division is not proposing to make any substantial changes to chapters 3, 8, 9, 11, 20, 25, or 26. We're doing a housekeeping today. We found we had some cross-reference errors that we needed to correct, and while we were doing our spring cleaning, we found some other things that we needed to just correct, and felt that it would be appropriate to do all of these minor corrections together. I won't bore you with the individual details. We have a number of rules, and there are a number of these minor corrections within them. But I will go ahead and just highlight what we did overall in this correction rulemaking. The primary purpose of this was to correct some cross-references. We've been actively doing rulemaking for the last few years, changing content from one chapter to another, and it meant that we had some legacy errors that we needed to correct. For instance, when we consolidated the UIC rules in 2015, all the references to chapters 13 and 16 were now invalid. So we've corrected those. We also had some outdated corrections to our sister division regulations for land quality. We wanted to make sure that if we're redirecting to other divisions, that we were capturing the correct chapter. And then from 2012, we had moved some content from our chapter 11 into a new chapter 26, but we still had some legacy cross-reference errors there as well. The other errors and other corrections that we are proposing to amend today are grammar situations. We historically have a habit of misusing the word which when we should be using that. And while that is not necessarily groundbreaking, it is an irritant to our advisory board, and they find that error every time we present to them. So we decided to take a moment and just clean up as many of those as we could find. I'm sure we've missed one or two, but we will correct those as we find them. We had some punctuation errors. We had some capitalization inconsistencies. The advisory board, the Water and Waste Advisory Board, has requested that we commit to one style of writing, and so we decided to commit to a combination of two based on the nature of the business that we do. We primarily are using the Chicago manual, but in cases where we have a legal need, then we rely on the legal blue book. And so they've asked us to be very consistent with those two styles, and that prompted some of these punctuation fixes as well. We had some odd spelling errors that we came across due to file format changes. A lot of these rules were originally hand typed on a typewriter on carbon sheets, and then at some point in the 90s, they were converted to WordPerfect. And then the state moved over to Word, and then those have been converted to PDF. And every time we convert to a new format, we get some odd characters that we don't notice at first. And as we go through rulemakings, those become permanent and as part of the permanent rule. So we've removed some of those odd characters. We had odd dollar signs and percentage signs where there should be letters or nothing. So we propose to fix those today. And then lastly, chapter 11, as you may have noticed, that was the largest chapter that we're bringing to you today. It had the most number of errors. It's had the least amount of revision to it in the 35 years or so since it was promulgated. And we were not aware until our advisory board looked very carefully. We had some metric conversion errors, and normally the state does not put metric conversions in our rules. That particular rule, that's our wastewater rule. It was based on the 10 state standards for wastewater, and it turns out that in addition to actually the 10 states is not just 10 states within the United States. It also includes provinces in Canada, which meant that they put metric conversions in their original standards. We just adopted those for pretty much verbatim. And back in '84, when we adopted them, I don't know that they had checked the math. And so there was some errors. So our engineering staff went through and recommended some corrections. We will note that when we do an overhaul to Chapter 11 within the next few years, because it's due for some technology updates, we will not be incorporating those metric conversions going forward. Because it's confusing, it's easy to make an error, and Wyoming is still using the English method. So that's the summary of the changes for those chapters. We did not receive any public comments during our 45-day notice period, and with that, the division requests that the council vote to adopt the rules as presented.
Thank you. Any questions? Deb? Dr. Bagley?
I just wanted to comment. I remember many years ago being given a book called The Elements of Style by Strunk and White. They said the first thing to do was go on a witch hunt. So it appears you've done that. Thanks.
Thank you. No. Well, with that, I would entertain is there anybody that wants to testify in any capacity? Okay, well, with that, I would entertain a motion to approve the rule changes.
I move to approve the statement and principal reasons for docket number 18-3102.
Thank you. Is there a second?
Second.
Been moved and seconded. There's no discussion. I'll call for a vote. Deb?
Aye.
Dave?
Aye.
Megan?
Aye.
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 And I vote aye as well.
I just want to make sure was the motion to approve the statement of reasons and the rule package?
Yes.
Okay.
Sorry.
I just get the whole lump sum. Want to make sure everything, all the i's are dotted and t's crossed.
Thank you.
Madam Chairman, I will return it to you.
Thank you, Mr. Flitner. Do I have a motion to approve the minutes from the March 29th, 2018 meeting?
So moved.
Second.
Do I need to do a roll call? Okay, all those in favor?
Aye.
Opposed? Motion passes. Do I have a motion to approve the motion to dismiss docket 17-3202A, which is the appeal of the NOV and order on Poverty Hill North?
I move we dismiss docket 17-3202A.
Is there a second?
I'll second.
And I will do a roll call since it's a motion to dismiss. John?
Aye.
Aye.
Tim?
Aye.
Aye.
And I vote aye also. So the motion to dismiss is granted. And do I have a motion to approve the motion to dismiss on docket 17-2201A, which is the notice of violation and order issued to Delton Tinsley?
I move to dismiss docket 17-2201A.
Or second?
Second.
Any discussion?
Yeah, I just wanted to remember what is it this case is about. I don't think we've ever had a hearing on this, have we?
No, we haven't.
No.
And
But the
this,
attorney for the DEQ, air quality, and the administrator for air quality are both here.
I said one of them to have something to do. They came all the way over.
I was going to be disappointed if I didn't get to talk about this. Counsel, this case involved a multimedia enforcement action against Delton Tinsley for allegedly demolishing a building without notifying the Air Quality Division that contained regulated asbestos, transporting it to his property, and then burying it. Over the course of 2 settlement agreements, we negotiated remediation activity at the demolition site, and we have a plan for maintaining the disposal site going forward.
Okay.
And as you can see, it's a joint motion to dismiss. Both parties have agreed to dismiss this case.
Thank you.
Thank you.
I'd be happy to answer any questions you have.
Any other questions? Seeing none, we will vote. Deb?
Aye.
Dave? Tim?
Aye.
Aye.
I'll vote aye also, and so we will approve the motion to dismiss on docket 17-2201A. Do I have a motion to approve the findings of fact, conclusions of law, and order in docket 17-1601, which is the Black Hills Bentonite permit to mine order in lieu of consent?
Chairman Lally, this is the findings of fact, conclusions of law that I emailed to the board on Saturday. So I apologize if you haven't. I sent it to the YO board's email address. This morning, looking at it, I made a few non-substantive changes, added I think when I was referencing Black Hills Bentonite, I said Black Hills, so I put an S there. What I have on all your chairs is the final version. So if you all want to take a few moments to read it, certainly do so, since it's the order that you will be approving. And again, I crafted this order based on your deliberations and your decision made, I think it was back in March. But I made very few changes from what was submitted on Saturday, and they were all non-substantive changes. Just word choice, typo type stuff.
So, do I have a motion to approve? We can't discuss until we have a motion on the floor.
Madam Chair, I was going to make that motion.
Okay.
Second.
Okay, it's been moved and seconded. Any discussion?
Madam Chair, I'd just like to take a minute to work through it.
Okay. Okay, is everybody ready? Do we have any discussion? Deb?
No.
Dr. Bagley?
Yeah, these, the order in lieu of consent always makes me nervous. Because we're not talking about people's rights, and the surface owner that certainly has a right to be involved in what happens when minerals are being extracted. But in this case, it seemed clear to me that the Black Hills Bentonite had done the 4 things needed to be done. And when that's the case, we should issue an order in lieu of consent. So even though I still struggle with the order in lieu of consent idea, the law has been met, and so I certainly will. We've already voted on this, but I think this order has been well written, and I'll be voting to approve it.
Tim?
No.
And I guess I will echo Dr. Bagley's statement about orders in lieu of consent. And I encourage the DEQ in the writing of their permit to take into consideration the concerns that were raised by the landowner, because they were legitimate concerns that need to be addressed in the permit. So,
Madam Chair?
yes.
May I just add something that you
Yes.
said, that would refresh my memory? Thank you. During the course, and this is for the DEQ, during the course of that hearing, we did hear a lot about truck traffic and dust, and we did hear some about some spills, maybe not spills, but leakage into drainages and whatnot. I think that the responses, the conversation response to that, I think, was okay. But I would just ask you guys to out of respect for the landowner, to go up there and track down some of those comments about, well, how bad is the dust? And is there in fact some leakage out of some ponds or reservoirs going into some of the drainages? Is there any kind of impact being occurring to some of the ephemeral streams near that permit boundary? You don't need to report back to us or anything like that. This is sort of outside of the question, but Megan said something and I just felt compelled to add to that. Looked like that's something you ought to look into. Thank you.
Okay. Seeing any more discussion? Seeing none, we'll vote.
Aye.
Aye.
Ken?
Aye.
Aye.
And I will vote aye also. So the motion passes. Okay, that concludes the public hearings for today. Mr. Bagley, Ms. Balmer, and Mr. Cora, as the subcommittee appointed to do the legwork on the study requested by the legislature in House Bill 1, could you give us an update, as well as Director Parfit? And let us know what our next steps should be. And I believe Mr. Ash was involved.
And Nancy.
And Nancy. So I guess if you guys, we could have a discussion on what your conclusions were and what we need to tell the Minerals Committee next week.
Well, thank you, Madam Chair. I'll just sort of kick off, and then all the subcommittee members, please chime in as we go. As you know, the subcommittee was formed at our last meeting, and immediately after that, we had an initial meeting to start discussing how to go forward. And we agreed that the first thing we wanted was to get information about things that a lot of us may not know very well, which is what our staff do to help support the council. And so we drafted a request for information that went out to every council member. went out to a number of DEQ people as well. Got that information back and appreciate everyone who submitted those comments. It was very helpful. We met again for about 3 hours over in Laramie on I think it was the 27th of April, to go through, discuss those comments, to start to put together what is going on. And I think it was really the committee's view is this is not a performance evaluation of any kind. This is to try to understand what it is that it takes to support our activities as a council from a staff standpoint. And then yesterday we had a very productive meeting with Joe and Jim, and they helped us better understand what's involved with running the staff portion of the council. And that's really so at this point we don't have any recommendations or anything. We're not that far, but we do feel that we've learned a lot about what's required and things that many of us didn't know, and things that I imagine other people don't know. And Joe and Jim may have been some of the only folks who really knew what was required. And so I'll just stop there and let other committee members chime in.
So, Madam Chair.
Yes.
I've got kind of an outline of what I thought we would present to the Minerals Committee.
Okay.
And for your consideration. It's essentially what Dr. Bagley just covered. But just to have that in front of us, basically the way this outline is structured would be just to reiterate to the members of the Minerals Committee what it is that they asked for. So that's what the first bullet is. And so you can see those are the kind of the work products that we've been asked to provide to the Minerals Committee and the Joint Appropriations Committees. The second part is just a description, like I said, as Dr. Bagley had described, which is, we established this work group, and then we've met 3 times since then. Just outlined who the members are of this work group, and then the last bullet on the first page is this update right now, just so that the committee understands that it's more than just a work group, that the full council is being apprised of kind of the work that we're doing. And then, Madam Chair, to your comment about, well, what are the next steps? So on the backside, I've outlined what I think are the next steps. That's something that we can modify if you all want to, if you add to it or whatnot. But first is, breakdown and evaluate the data and the information that we've collected. And then clarify what the needs are for the council based on what the information that we've heard and collected. And then what's the most efficient and appropriate means of providing those services that the council needs. And I think that gets into the recommendations, and that'll start getting into helping us understand what the costs are associated with it. Is the budget currently appropriate, or do we need to add funds to the budget? Do we need to reduce funds in the budget? I don't know. Staffing level needs, statutory changes, and that's really kind of I think the key part is, are there any statutory changes that we're going to recommend, and what would those be? And then we would prepare the final report prior to November 1 of this year. And then questions and requests from the Minerals Committee, and this is just want to make sure that the Minerals Committee understands what the process that we're embarking on, and to see if we're on track. If they say, well, we'd really like you to look at this too. This is what we meant in this provision. But I think we're on track, but it just gives them the opportunity to ask questions. So that's essentially what I think we should present to the Minerals Committee, keep it at a very high level at this stage. And certainly, like you said, we don't have any recommendations. So.
When's the Mineral Committee meeting?
First.
Next week, coming right up.
In July.
Yeah, Madam Chair, if I may, also wanted, this is an opportunity for council members who aren't on the subcommittee to ask questions, make suggestions. You know, the committee has a task, but really it's the council. My hope is at the end, when we come together with, when we submit this final report, it's something that the council has had a chance, and we haven't written it yet, but a chance to fully read through it, vet it, make suggestions. Our intent is that this would be as open a process as possible. And so if there's anyone, if people have questions at this point, we certainly try to answer them. We can, and certainly get your feedback as council members.
Yeah, I've got a question. How do you address the issue? Because this is kind of two-dimensional. I mean, we've got the services that our staff provides for us, and then we take those services and we provide services to the general public and mix that in with the DEQ. So when you're talking to the Minerals Committee, how do you formulate your direction on the end result? I mean, because you can get bogged down in what Jim and Joe do, but what's really important is how we take those services and turn them into what works in this process. And so I think it's important for the Minerals Committee and whoever else to understand that, we can pick at our staff a little bit, and sure, we can streamline it and do all these things, but in the end, if it wrecks our system going forward in the next dimension, we really haven't saved anything. And that's the feedback that I keep hearing everywhere I go is it's only as much what the staff does for us is kind of equal as to what we do in the services that then we provide with those services. So if the general public perceives us in a separate way that causes us grief down the road, or if we don't make the people that are making these decisions understand that this is two-dimensional. It's not just about doing it the cheapest way to get those resources to us. And that's a hard thing to explain even to ourselves, let alone, because I've been there. I've been before the Minerals Committee trying to explain that before. I mean, this isn't the first time we've had this come up. And you could tell about half of that board understood it. About a third of the board didn't want to hear it. And the other third didn't understand it. And it was hard to sway any of those people, as I recall. I mean, they had an agenda, and that's where they were headed, and it was really hard to move them. We started that discussion, and you kind of knew where people were, and we ended that discussion, and those people all voted just about where you knew they were going to vote. I mean, we didn't move anybody. And so I think that's a real challenge, and I don't know how to get there from here.
Well, as we've been working on this, Tim, at least for me, and I think for the others, and I know for Todd, in the back of our minds is exactly that presentation package. Mm-hmm. And how do you present that and explain to that committee without getting into the weeds, but in a cogent way, what the work of the job is to support the council. So I think we're okay. I see a nod. Let somebody else add to that, but your comments are right on. And it's sort of we touched on it a little bit yesterday that this upcoming Minerals Committee meeting is going to be our Megan's 5 minutes of fame. I think it's probably going all the way up there and all the way back for that. But the big one will be in the fall when we make the presentation. And we discussed yesterday the idea of having a dry run. And I think, this is just something that's off the top of my head that based upon what you're saying is that perhaps we could do that with the full council at a meeting. I don't know procedurally how that would work, but you all, as Dr. Bagley said, this is really coming from all 7 of us, not just the 3 in the committee. 6. So perhaps you could participate in that dry run, and I think maybe the dry run would be the way to go to and tap into some of your experience with that committee as well. Yeah,
well, I think there's going to be some very negative comments or questions, and that's my fear. And I want to make sure we have the answers to those questions.
Well, I mean, if you're asking me how it went before, and I'm not saying I handled it well. I don't remember what everybody else thought. I remember what I thought when I walked out of there, but there will be people that already have an idea where they want to go. There will be people that say Jim's job doesn't need an attorney. There will be people that say we should be staffed by the DEQ. There will be people that will be on the completely opposite end of that and say that is an independent, this whole thing proves that it should be independent. You shouldn't have legislatures lean on. And so those people that have what they kind of think should happen in their mind, those questions will lead you right into that. They will say, well, Megan, can't you do that job a lot cheaper? Or can't the DEQ staff your people, and then when they're not busy, they can be working over there? And all that stuff kind of makes sense. Just from an accounting standpoint, of course it makes sense. And of course they can. But this is the second dimension. Not if it leads you into an appeal process that is backbreaking for the AG department. Because the people out there do not have any confidence that we can all get together over coffee and come up with a decision that helps them when they're on the opposite end of the DEQ or whatever. I mean, so it's a hard line. Of course we can do it cheaper. Of course we can do it on the first dimension. No question about it. But what is the cost down the road if people don't believe we are authentic? And that was the hardest argument to put forth before. I think that the line that the tack they took before was Jim's position should be appointed by the governor. That's basically what, I mean, we got a little different line going into this one, but that's where they were coming at us before. And I just said, well, fine, but you might as well go ahead and have him appoint the janitor for the building and this and that and the other thing. I mean, really, your problem is, and I think, Megan, this would be my advice for where you stay. Your problem should be with the council. Are they or are they not doing the job? And if they are, then leave them alone and let them do their job. If they're not doing the job, then replace them with people that can or will. And I told them that straight up. If you want my resignation, or if we're not doing it right, then you should ask for it right now and you'll have it. And then appoint somebody that does what you want them to do if that's what you want. But start at the top. Don't start with the staff. I mean, if you have a goal in mind, put people in place that get you there and then let them handle it. Micromanaging our staff doesn't get you there. I mean, let us do our job. And that's kind of the meeting that I had earlier last year with the governor's office too, is if you keep putting training wheels on boards like this, pretty soon you don't have much of a board because people don't like training wheels, and people that are qualified quit serving. And as soon as it turns out to be just a rubber stamp kind of a, anyway, you know where I'm going with that, but keep in mind, I think you want them addressing us more than our staff. That makes sense to me. I don't know if it does to anybody else. But.
You hit the nail right on the head. And I think somebody mentioned this is not a performance appraisal thing. So this is, and it's important that we keep, we keep, and it's not, and we can do this because we're in the driver's seat delivering this presentation and talking about it. And so focusing in on this is the work that needs to be done for the council to function, and avoid even opening the door to have some sort of a side conversation about whether somebody likes the decisions or not. If they want, I think that as the legislature, wrangled its way through this last session and got to where they got to with the statute, I think the smart minds prevailed in the legislature, to be honest with you. And I think they said, look, this should be funded for 2 years. And okay, fine. It's not a bad idea to look at this, that needs to be done and how it's staffed. It's up to us to make sure that we keep that very high level. And we've talked about that too, Jim, in the subcommittee. And And as Molly says, you just never know what kind of question you might get. We'll just have to be prepared.
And half the time arguing with each other too, so you like your thoughts.
And this is something that I've been, this all came forward. Hammer that they used on us, staffing legislation. And I don't know if we want to address this or if it would possibly cause more problems. Probably needs clarification. The legislation, the 3012D. I mean, after us on it was DEQ will provide.
So, and I can address. One of the things I think we need to do at this meeting, at that very high level.
Right.
I think, Tim, the point, good points that we need to capture in the final report. Mature to go down that road because I'd be the committee then giving them something to try to drill down on when we have no answers for them at this point. But as far as the land, I mean, that is kind of the crux of it. And I think there's an opportunity here. You know, as you look at the last time you went through this, and I don't know a lot of the details of that specifically, but it seems to me this is an opportunity to look at the statute, look at what the functions the council needs to support the work that you do. And that could be some change, no change, whatever. But it's an opportunity to look at the statute and say, okay, now that we've defined what it is that we need, is that laid out in the statute that says, you know, you got the Environmental Quality Council, well, how you staffed? And maybe this goes away. This paragraph D goes away, and then we put something in that we think is more appropriate to actually. I think there's an opportunity here to avoid potential, I mean, to the extent you can, potential conflicts like this in the future.
Yeah, I mean, I don't want to dump this on the next person 10 years from now, you know, with this exact same fight, you know, over and over with the new legislature.
So I guess what we're saying is that we don't, at this point, really have a position on where we are with that so far. I mean, we're just still trying to identify the jobs that they do for us, the services that they provide. So we're still kind of in an information gathering process. That's basically our position at this point.
Yeah, I'd say that's pretty accurate. And there are some things that the agency does, and I think we would continue to do. That to me is more administrative. You know, the human resources and accounting and that kind of thing. I don't think it makes sense to really get in there and change that. It's more of the services and where those, you know, the services come from. You know, this idea that we could just take two positions and say, well, all that work that's being done can be handled by DEQ without the resources. I mean, that's a non-starter for me.
You'd have to replace those. I mean, if for some reason the legislature said, no, it'll go to DEQ, you would basically have to hire Jim and Joe to do those jobs, right?
I wouldn't do anything different.
Yeah.
They would just,
I mean, you would still have to hire two new employees. It's not like the money, that money goes back to the general fund. It goes to do two different employees or the two same employees working for DEQ rather than for EQC.
if that's what they chose to do.
I mean, you couldn't do it with the existing staff you have.
See, I think but that's why it's critical that we present this from the standpoint of what's the work required to support the council.
Right.
Because that legislature has the unique capability to say, no, I believe that Todd has a bunch of people sitting around doing nothing and this will fill their day. I mean, you know, that's.
Yeah, well, that was the question I was asking, was, do you have people sitting around doing nothing?
They'll look for ways to cut spending, right? And they'll follow their instincts on that. And that's why it's up to us to put together the information for them in the sideboard so that they know that what that work is.
Right.
Yeah.
And that's why I think we, as you mentioned, John, we are in the driver's seat. I think we have the opportunity to frame this thing the way we think it should be framed, because right now it's pretty broad the way they've laid it out, and they've given us some latitude. And I think the direction we're headed as the work group is the right direction, where we can then really define what it is that we think the council needs. And that'll be hard for them to push back on, or harder to push back on, if we are going in there together saying, look, we had this work group and we come up with these recommendations and we think this is the right way to go.
Yeah, if I could add, the subcommittee has looked at that statute. And it's, there's some very vague aspects of it. And if there's ways as we go through this to make recommendations so that the statute can be clearer for all parties going forward, for the council, for DEQ, for the legislature in the future, to look at it and say, oh, that's what it says right there, about the support that needs to be provided. That if the subcommittee comes up with some ideas, certainly the council will get a chance to see them and see what we're trying to do. But we have discussed it, and we know that, well, I think we're in agreement that you could drive a truck through parts of that, statute when it comes to how you might want to interpret it. And I think that's part of what we've seen. Yeah, it can be interpreted different ways, and what would be wrong with helping it to get really at what you're saying, Tim? The council, as a council, needs to be able to do what the legislation, the statute wants us to do. And at this point, with some of the uncertainty in there, we end up playing this game periodically.
Yeah, and it's frustrating going through this cycle, which tells you you've been here way too damn long. You're repeating things. That should be your first hint that, hey, you are way overdue. way past your expiration date. But having dealt with, a lot of federal bureaucracies and BLM and the Forest Service, and Army Corps of Engineers, all the things we do in agriculture, the one thing that we always felt we needed more of and couldn't get was agility and flexibility. And so when you look at these things that are written vaguely, that would have been in a lot of cases for us over the years a breath of fresh air, because it allows agencies to move and to change and to adapt and to do all these things. So there is a downside. I wouldn't disagree that this needs tightened up, but I think you want to be careful too how much you tighten it, because flexibility and being able to work with all these other agencies that we work with and all these things, without that agility and without that flexibility, then we start getting into places where we can't make the decisions we want to make because we're boxed in. So there is an argument to say that, look, the intent was to be somewhat vague and to put reasonable people in these places and in these positions that would come to the right solutions on their own without sending them down these rat holes all the time, because you're hemmed in by policy and statute, et cetera, et cetera. You get the right people in the right places and you get enough of them, and there's 7 on here. Surely with your help and everybody else's, we can usually get to the right decisions. And I think for the most part, going forward, I think that's the main thing we rely on is, hey, I would disagree with just about anybody who said that this council over the years that I've been here has not done a pretty good job and not come to the right decision on almost every occasion. We've had some shakeups, sure, and maybe we got a few things wrong, but for the most part, I would argue with Mr. Agopian all day long that we're not doing it cheaper and faster than anybody else. I know damn well we are. Go look at the district court system and try your hand in there. I've been there too. And I'm telling you, it makes this thing look like a horse race.
So who's gonna be there? I'll be there.
I'll be
Director
there.
Parford will be there.
I may be there.
Welcome anybody that wants to come. And it's at 8:00 on the 1st, right?
8:00 Friday morning. Yep.
I won't be there. I'll be in Tucson. Grandkids.
Where it's hot.
Yeah.
And I have a conflict too. I won't be there, but I have all the rest of the conversations, I will certainly be there with you.
Well, I will certainly be there.
We'll be right behind you, Megan.
Just don't turn around because we may. Trust us, we're behind you.
I just wanted to ask Todd a question. I've been at one minerals committee meeting and they had an agenda and then they didn't follow it necessarily. They got done early on some stuff and then stuff for the next day they went ahead and pulled in. Is that, I don't want Megan to be driving up there and they already had the hearing. And I just don't know if they still do that or if they're pretty consistent on their agendas.
I'd say they're pretty consistent, and I can talk to the chairs because we're up all day. I mean, we are the agenda on Friday, not EQC. That's 20 minutes of it, and then we've got 3.5 hours of land quality. Yeah, if anything, we'd move the land quality stuff, and that would bleed over into the next day. But I don't even want to do that because we're planning on Friday morning, and I won't have all the people I need there either.
Because it happened to us, and it was like, whoa, we're here already.
Yeah, so. But I think just an explanation to the chairs, they would understand, and we just hold it in the morning. And there's probably a fair amount of public interest in the topic as well, I would think. And so they would want to make sure that everybody had the opportunity based on when the agenda was set.
There's been 200 articles about it. So.
While I was thinking about it, there was something that came up today. I'll just take the opportunity now to ask Jim or Todd, depending upon where this data resides. For our committee, it would be good if we saw those graphs that Jim said he prepared for the budget so we can kind of see the spending levels over the years.
B102. B102.
Well, I don't know. Yeah. But, say for the last 5 bienniums, just for 4, whatever you do. This is the biennium budget. This is biennium actual spending. We talked yesterday about you do that sort of thing. B102 or B39 or
yeah, Laura before that, Nancy before that, Jim.
So I can check on that.
Yeah, I can just call Laura and she can whip it out. Every month I get what they call a B102 report that shows actual spending. And then Jim years ago gave me an Excel sheet that I enter that data in, and then it creates 3 graphs, a line graph and a tower graph, whatever you want to call them, that shows a line of here's what your proposed spending would be and here's what you actually spent.
Right. I think for our committee, we need that at some point, and since it came up, I just wanted to ask for it.
And if you're done with that discussion, I just wanted to bring up one thing that kind of this whole process is done. And it has to do with this stuff. One of the things that you need to decide as a council is what services you want going forward. And it came up yesterday, and Joe and I are kind of sitting here going, well, we gave you everything we've done. It's not necessarily everything we do. Like today, we may do this. With the next council, they may want us to do something entirely different. For us right now, though, this is an issue. And you guys, for us to go anywhere, you guys need to decide, do you want the service that this does for you, broadcasting, allowing people to testify in, externally, those kind of things. If you want those things, then at some point I'm going to have another discussion with you about how we deal with this moving forward. We need to make it smaller. It's a really good machine. Don't get me wrong. I've told you that this is a top of the line machine. It really is. But what really brought it to a head for me was Joe had recent surgery and he can't lift more than 10 pounds. I'm not a muscle man.
Or maybe you can get on the weight.
I can get it out. I can't get it in. So eventually I need to know whether or not you want us to provide these services. And if you do, then I need to have a discussion with you about where we go with this. Because, you got to admit, Joe and I aren't going to be here forever. And if this is a service you want to continue to give future councilmen later, we need to start thinking about whether 2 60-year-olds are going to be doing, or whoever. I mean, Joe and I won't be here forever. We know how to handle this stuff, but we're getting old and that's getting heavy.
Well, I don't know how the other committee members feel about it, but I think that's that sort of question is right in line with the charter that we received from the legislature. And I would suggest that you do that now. You begin to think that what it is you provide in this video conferencing, electronic IT kind of arena, and give to us what you think.
You've got that.
Okay.
You've got that.
Okay.
The list of things we do in there is in that paper I gave you. But yesterday when we were talking.
How do you do it though? I guess I saw that, and I think you're talking about, maybe, probably me, I apologize. But I think what you're talking about is, okay, two things. One, does the council want to continue to have its meetings broadcast and have accessible the way we currently do it, right? And you say that's described in the write-up, which I think I saw that.
Right.
The second piece you said was we got to think about how we buy new equipment that is up to date and easier to handle. Is that right?
Right.
Yeah, and I guess we would look to you to recommend to us what that equipment would be. Right. Because if we do the budget recommendation for money in November, we're gonna need that backup information from you. So
and we are working on that right now.
Okay, sure.
Joe and I yesterday, and Joe's been doing it for quite a while.
Yeah, but you'll get it to the committee.
Right. Is looking at how to shrink it down.
I've got a specific question for you and Joe, Jim. I know over at UW in the last couple of years, we've gone from having one room on campus that was able to do all the things that you guys do by carrying stuff around, but the room was set up that way, to many, many rooms that can do that. And so what I'm wondering is we look across the state, are there, and UW is a state organization, community colleges, is the capacity outside of this area gotten good enough that we could go in, say, to a community college, one of their wired rooms, and get the same kind of service without having to lug stuff around? Now, I know when you started, you couldn't, but I'm just asking if that's available.
And this is a great room to be in for that. If you look above you, there's 3 microphones. So I haven't seen the ones in at the university, but I know they're better than this.
Yeah.
This was built, quote, if you look over there, they've got basically the same setup as we have here. A little different, but basically the same. They can record and they can amplify. They can't broadcast. They don't have the cameras. They don't have the technology to truly capture the discussion in a way that is transmittable. Joe's much better at this description than I am, but the bottom line, the reason we have so many mics is so we can, when you broadcast it and you record it, you hear the person and not 2 people, and you can split it out if you want to hear the discussion of, well, what Dr. Bagley say at that point. So you're preparing minutes, or somebody wants to come in and hear, we're confused. We can pull out your voice and give them nothing but that. They won't get if they want to hear the question and answer. So if Deb asked you a question, you answered it. We can give them that without giving them a bunch of other stuff. We can edit it down to what they want.
Yeah, so I guess what I'm asking is, I think the system we've got is good. I'm just wondering, and maybe you guys could start chatting with folks at some, this room, the way it is now, no, it wouldn't work. But I'm just wondering if some of these other facilities, I know in the last couple of years, the UW has finally moved into the modern era, and we can deliver courses. I've had committee meetings with people on Zoom, and they've gone to much, much better. It used to be, man, it used to be terrible. And like this room is kind of example. We got sort of Wi-Fi over here, but if I stand in that corner, I got a lot better Wi-Fi. No, we got to have facilities that can meet our needs.
And over time, we don't do a lot of the because we just had. The community colleges as well have done some upgrades.
Yeah.
Whether or not those upgrades are sufficient, but let's just say all the service you wanted to provide was the broadcasting. I mean, that cuts down on some equipment that we would be taking. But in order to do it, we would have to be able to plug into their sound system so that we could adopt it and send them on. We wouldn't have a record, but those are things I just want you to think about so that, and you can tell us, are these services that you want? And are these services you think the future council members will want? If so, Joe and I can then go through and decide how to downsize this to give you those services.
So can I say something really quick?
Well, Joe's been wanting to say something. I'm sorry.
Okay, Joe, go ahead and then.
Now, you're right, there's lots of rooms that they're broadcasting video, they're doing great jobs, they really are. The problem with it is when we walk in there, they don't want to dedicate their video or their IT guy to us. And they don't want me to mess with their stuff.
Mm-hmm.
Okay, so that is the biggest problem now. Just like this room, I'm sure when they first built it, they didn't let anyone touch that stuff. And now they don't have any problem with it at all. They welcome us to use it, drop the use projectors, and do all of that stuff. It will get that way, but it's still new enough that they don't want me to walk in there and do it. Otherwise.
Well, I mean, I can understand. They don't want you touching it, and so you'd need support from them. Nancy, oh, there you are. You had a meeting right after us in that room over. Did you guys make full use of the audio video capabilities of that room?
We didn't have anybody videoed in. We've done that before. That particular meeting we did, and they do have the like what Joe was saying, someone from their staff to help do some switches or whatever. I'm not very tech-oriented.
Well, and that was my question. Did they provide help? Because that is key. Absolutely. If you walk into a room, it could be the greatest room, but if they won't let you touch anything and they won't provide any service, then it's no good.
Yeah, when air quality makes room reservations and we want to have certain services provided, we make sure that's the room that we book that has those services. And if it's, hey, we need somebody to help, we say, hey, we need somebody to help with it, so we know if we're going to get that or not.
Okay.
And that particular one we do every time.
Yeah, that particular room is one of the best
Very
on
nice.
campus, and they should be able to do that. But yeah, but you're right, Joe, and that's why I'm just asking.
Yeah.
Because I think it's me personally, I think that what we're doing is the right thing. We're broadcasting, we're taping, and until when I first came on the council, this is one of the few places I saw all that happening, and I just have seen it evolve. I mean, when we interviewed our current president at UW, all the interviews were broadcast live, and they were also stored. And so I know that UW has finally gotten that capability, and I imagine other places too, but they still have to be willing to work with us.
Yeah.
But they're a state agency, and we're a state agency, so you would hope, right, that they could talk together and work.
Yeah. Well, like Riverton I think it's Riverton has really nice city hall room. They broadcast all of their meetings and they have all that equipment. But every time we've been there, just even mentioning, looking at their stuff, causes them to.
Yeah, they're not a state agency.
Yeah. So that's why we bring our own.
Yeah.
That way we don't have to scare them, we can go in there and do everything we want.
So the problem that I want to address, and Tim knows what I'm talking about, and probably Steve also, half of our meetings when we're doing hearings are in little towns, Bags, Grable, Sundance, just as examples. And they're a long ways, a lot of them are a long ways from any of the community colleges. I mean, if we're having a hearing about something in Bags, people don't want to drive 2.5 hours to Rock Springs or, Evanston.
As long as they
And so,
I can do it.
It's important, I think, we have our own capabilities because Wyoming's too big of a state with too many small towns to just rely on whatever town happens to have that. I mean, when we met in Buffalo, we met in their fairgrounds. It was a very basic building. You know, just a metal building with folding chairs. And it was a good hearing, but they're never going to have those capabilities in those towns. So, in my opinion, we need to keep having our own equipment until things get several more generations further along. I mean, the university's great, Cheyenne's great, but this is a fairly unique corner of the state.
I think the legislative intent, and I think the expectation of the public is that we show up some of these places, so.
Right, that's what I mean.
And that's where you're going with that.
I think that's important too. People have come to expect it.
Well, and they're not getting paid to, or even their motel rooms, to come to Cheyenne to testify, you know, and that's a lot of time.
Yeah, we ain't either, really. Especially if you look at my last accounting schedule from them.
Well,
I
actually,
got really paid well.
I got paid really well.
And then you had to give it
And I had to give it back.
Right. Yeah. But I guess we as a council need to have a discussion, and we can have it now or we can schedule it for a meeting. What services do we want to still have things broadcast on YouTube, or do we want to go back to, somebody wants to know what we did, they can read the transcript? What do we want to do as a council?
Well, I'll chime in. I think what the broadcasting and being stored somewhere accessible by the public is, we started it. I think it's great, and I think we should keep it. It is the way things are going, and you know, if it's going to take some technology, the technology continues to improve. I mean, I was just thinking as I was listening, I wonder how long it'll be before we all just take our phones. I'll actually have to buy something besides a flip phone, but you know, take a smartphone, dial in, and we can all be anywhere having our meeting, and we're all linked in. I mean, the technology is moving towards that, but I don't know when that'll happen. And I don't have to buy. I like my flip phone, but
I hate video chatting. I don't want anybody to see me. Deb, what do you think?
You know, it's one of the subjects that we're discussing, you know, in our group as well, you know, of the whole IT thing. But where we're going to get it, how much we need, you know, what we're going to do with it. It's come up anyway, and it's just been one little part of what we've been discussing in our subcommittee, and hopefully we can, you know, have some recommendations for this whole group after we've had a chance to work our way through to that component of it. I don't know. I'm just not quite there yet.
You don't know. You don't have an opinion yet.
No.
No, I think our group should not forget that comment and tee it up. And I think where it has a lot of, there's a big implication here in terms of the budget aspect of how we talk to that committee this fall. Because I know in the past, Jim has taken some heat over state plane, you know, getting us all to a place where we have meetings. And you know, the sense of my sense of the legislature and the state is that there is no problem that can't be solved by IT, and therefore you can reduce travel. You know, I hear it all the time when they're focusing in on the staff. You see the nods over there. And I think the council should develop a position about how far we think we need to go with IT in term versus showing up. And the small town, large town, how we, so I just kind of, hopefully we'll remember in our next committee meeting to begin to deal with that. We may need to get some input from the council again on their feelings about that.
Well, you know, one of the tacks that was pretty successful dealing with the Minerals Committee and the legislature years ago, and Governor Friedenthal was, what do you want us to do? I mean, we can do whatever you want us to do. We can do $10 worth of business a month if that's what you want to do. We can do 100,000 if that's what you want. I mean, what do you want us to get done? Do you want us to travel? If you do, you gotta fund it. If you don't, fine. I mean, take our dog out of the fight, basically, and say, look, we serve at your pleasure. Do you want us to travel around the state? Because they're talking to their voters. And I can tell you, most of their voters want them to travel around the state. The people that are whispering in their ear are telling them, hey, we'd like to see those guys outside of the one corner of the state once in a while. I mean, everything that happens in the state doesn't happen within the Cheyenne city limits. And if you travel around the state, that's a big concern, not only in this arena, but in every other one too. So put it on them and say, look, if you want us to travel, we're probably going to at some point have to upgrade our systems. We can't be lugging that around. If you want us to cut staff, we need something that can be handled maybe by one person and not two. Those are the kind of things that can be put to them pretty easy. And they can decide, hey, you know, we're not going to give you upgrade your equipment. Okay, fine. We'll have all our meetings in Cheyenne. You know, you can explain that to the gravel mine people that are up in the farms in Sheridan and why 20 of them got to load up and come down here to a hearing. I mean, your representative from Sheridan County, go call him and he can explain that to you. So those are the kind of things that if you put it on them, some of them get pretty reasonable pretty fast. And then all of a sudden, $5,000 here or there doesn't seem as important as it was when they just wanted to jerk it out of the vacuum and they think there's no consequences for it.
So just if I could add a few things to that. On the IT system, I would say we would, once it's decided what is the right size system and what do we need, what do we want, I think somewhere in there's a conversation with Tony Young with ETS and say, how do we, this is what we want, what's the best way to deliver that? And put some of that on the centralized IT agency for the state. And because I think he'll have some of the answers, but he'll also be critical if we move forward with any recommendations. We have to have him behind us or it's not going anywhere. So that's on the IT part of it. On the state plane part, my thoughts would be if you just said, look, there are going to be so many meetings that we're going to use the state plane. Some of them we won't, but we're going to say we want this many trips with the state plane, and then work that into the recommendations and the budget request. You know, right now it's not in the budget at all, as far as I know. And the Industrial Siting Council, that's never been an issue because that's part of, you know, how we operate with the applicant pays a fee for the hearing, for the staff time, for the council time, and for the state plane. And if they don't want to pay for the state plane, they got to pay for all of the travel and the hotels and everything else that comes along with it just to get them to the hearing. So, and then it drags the hearing out 2 more days for the council members, which, you know, an applicant doesn't want an unhappy council, I would think. So anyway, so there are ways to make that happen. You may not have it available all the time, but just to work it into the budget. So.
Does that plane go in and out of Pinedale?
Yeah, we've been there many times.
Say it'll go out of
Then I would
Dixon.
vote for that.
Well, it used to come to Grable, but not anymore.
It was that trip that got half my ass chewed up.
Yeah, I know. I remember that.
So Steve, I know you're new to all of this and you might have an outside perspective a little. What do you think?
Well, I enjoyed hearing from all of you on this and taking in all this information and processing it. When the survey went out to what kind of services do you need to do your job, I had to reply. I couldn't reply simply for the fact that it wasn't fair to make a recommendation either for or against something that I hadn't experienced yet. So this is a real information gathering meeting for me. And I agree with so much of what's being said about how to move this around the state, how to be visible, how to be present in we deal with subjects and issues that are so relevant and the ramifications are such that we need to be in amongst the people as we make these decisions, right?
Thank you. Does anybody else have any more comments, questions?
Just one statement. One of the things you have to remember when we're talking about the system and what you want is the size of the people. They can have rooms, no, not the physical size of the people, the number of the people. I saw that smile. We take up a lot of room. And a lot of, at least in the past, these systems have been in fairly small rooms that they've built. They're not built for what we did in Sheridan, you know, so that's all I.
Well, we need to make it resilient enough that it can work in a room like this or work in a metal building on the fairgrounds of Buffalo or Rollins or whatever. Just because, you know, what works in a closed insulated room in an echoey place might not work. So we need to make sure we address that too. Okay, well, if there's nothing else, I guess I need a motion to.
I move to adjourn.
I second. It's been moved and seconded. All those in favor?
You guys want to go out of here, or you want to have lunch? Uncle Charlie's is just around the bend over here. They provide a really good lunch.
I'm gonna head out.
I gotta head out too.
Can you just call and I can coordinate on next meeting?
Yeah.
I'm not really-